Despite deeply troubling developments at the border and in our courts, there's still a path forward for asylum seekers. The Trump administration has made some shocking moves in recent days that suggest they're willing to ignore judicial authority entirely. We need to talk about what this means for you asylum seekers. I'm going to tell you about 3 moves the Trump administration has made in the last few days that portend bad things for asylum seekers. Be sure to share this video with people in your community who need to stay abreast of immigration developments. I'm Brian Manning, and I used to be an asylum officer with the government. But now, as an asylum lawyer, I help immigrants all over the country secure their future in America through asylum. Let me know in the comments if you've got an asylum case pending or are considering applying. I'd especially like to hear from you if you've been waiting for an asylum interview for multiple years. Let me know how long you've been waiting. Before diving into the concerning news, I want to share something hopeful. Just today, our firm received an approval notice for one of our asylum clients. I feel like I need to provide you with this glimmer of hope before getting into yet more depressing immigration developments. The truth is that even in this challenging climate, my law firm continues to win cases. Under the first Trump administration, we won. Under Biden, we won. And we're still winning now, despite Trump's best efforts to crush asylum. A well-prepared, properly documented asylum case can still succeed where the applicant is willing to put in some work to prepare and has an experienced asylum lawyer guiding them. Now, let's examine 3 recent incidents that suggest Trump may be willing to defy the law and the courts when it comes to immigration enforcement, and why this matters for asylum seekers. The first incident involves the mass deportation of Venezuelans to El Salvador. Last week, the Trump administration invoked the Alien Enemies Act of 1798, a wartime law that has only been used 3 times in American history to justify the immediate deportation of Venezuelan citizens alleged to be members of the Tren de Aragua gang. When 5 Venezuelans in custody filed a lawsuit to block their removal, a federal judge from the Federal District Court in Washington issued a restraining order blocking deportations under this act. The judge sounded a skeptical note on Trump's plan to use this law and said deportations could not go forward under it while the lawsuit winds its way through court. During the hearing, the judge learned that 2 planes carrying Venezuelans might have already departed and been in the air, and he ordered the government to turn those planes around and bring the deportees back to the United States. What happened next was stunning. Despite the judge's order, the flights continued to El Salvador, where approximately 238 Venezuelans were transferred to what their president, Nayib Bukele, called a terrorism confinement center. Bukele even mocked the court order on social media, posting, "Oopsie, too late," a message that was then recirculated by the White House communications director. Even more troubling, Secretary of State Marco Rubio publicly thanked Bukele, and White House Press Secretary Caroline Leavitt released a statement questioning the judge's authority to issue the order at all, claiming federal courts have no jurisdiction over the president's conduct of foreign affairs. The exact timeline is still being pinned down, but from all indications, it does look like the planes were probably in the air when the judge issued the order, such that DHS could have transmitted a message to the pilots to turn around. That clearly did not happen. Look, when a presidential administration suggests it can simply ignore court orders it disagrees with, we're stepping into dangerous territory for our constitutional system, and it's especially foreboding for immigrants who are right now one of the main points of focus of Trump's ire. By the way, if you want to maximize your chances for asylum success, then be sure to hit the subscribe button and bell notification so you don't miss the insights that I share on this channel. Okay, the second incident involves a doctor who was a kidney transplant specialist and professor at Brown University's medical school. She is a Lebanese citizen who had recently received a valid H-1B visa from the U.S. consulate while visiting relatives in Lebanon. When she returned to Boston's Logan International Airport, she was detained by Customs and Border Protection officers for 36 hours. The doctor's cousin filed emergency legal petitions to prevent her deportation, and a judge from the Federal District Court in Massachusetts ordered the government to provide 48 hours notice before deporting her. Despite this court order, and despite a lawyer physically going to the airport to inform CBP officials of the order, the doctor was put on a flight to Paris, presumably en route to Lebanon. In a second order, the judge wrote that there was reason to believe CBP had willfully disobeyed his order and demanded an explanation. This case is particularly disturbing because it involves someone with specialized skills who had followed all proper legal procedures and obtained a valid visa. The doctor was working in a field with a shortage of American doctors. Even with a court order protecting her, she was removed from the country. But there's more still from last week that you need to know about. The third development is the revival of family detention. After falling out of use under the Biden administration, the Trump administration has reopened detention facilities in South Texas specifically to hold undocumented immigrant families, including young children. These facilities in Karnes and Dilley, Texas, are being readied to hold thousands of people. Reports indicate that multiple families are being detained in rooms with 4 to 8 bunk beds and shared bathroom facilities. While these centers are supposed to provide some medical care and educational instruction for children, human rights organizations have long documented serious concerns about conditions in these facilities. Family detention was previously used during both the Obama and first Trump administrations, but faced numerous legal challenges. The practice was largely abandoned after courts limited how long children could be detained. Now, border czar Thomas Homan has indicated the administration plans to challenge these court-imposed limits. What's particularly noteworthy is that unlike in previous years, when most detained families had recently crossed the border, many of those now being detained have been living in the United States for months or years, with established ties to communities, working jobs, and attending schools. When we look at these three incidents together, a disturbing pattern emerges. The Trump administration appears willing to not only implement harsh immigration policies, but to disregard judicial checks on their power. White House Press Secretary Leavitt's statement that court orders blocking Trump's agenda are unconstitutional and unfair signals an administration that believes it can operate above judicial review. This creates a genuine constitutional crisis. In our system of government, the judicial branch exists specifically to ensure the executive branch doesn't exceed its authority. When a president suggests courts have no jurisdiction over their actions, we're watching the erosion of the very checks and balances that protect our democracy. For asylum seekers, these developments are understandably frightening, given that much of Trump's focus in his first months in power has been on crushing the immigration system generally and targeting asylum seekers specifically. But I want to emphasize again that there's hope. Asylum cases continue to be granted. The asylum system, while under pressure, still functions. Officers and judges still approve cases that meet the legal requirements for asylum. And yes, those people granted asylum can go on to apply for permanent residency and then later for U.S. citizenship. So the path to safety and stability still exists. What all this means for asylum seekers is that preparing the strongest possible case has never been more important. You need to be meticulous in documenting your claim, thorough in your evidence collection, and precise in your testimony. You need to know exactly what officers and judges are looking for, and you need to present your case in a way that makes it as easy as possible for them to grant you asylum. Thorough, expert preparation for your asylum interview or hearing is now more important than ever. Even in this hostile environment, well-prepared asylum cases continue to succeed. Our firm has helped clients win asylum throughout changing administrations and policies, and we're continuing to do so now. And know that the legal community is fighting back against these concerning developments. Lawsuits have already been filed challenging each of these actions, and many judges remain committed to upholding the rule of law regardless of political pressure. What we're seeing is deeply troubling, but it's not the end of the story. We'll keep up the good fight on behalf of our clients. If you're ready to take the next step and get help with your asylum case, call my office today. That number is 713-909-0401. Remember, we help people all over the country, so it doesn't matter where you live. Call us now to schedule an Asylum Strategy Session so we can help you secure your future in America through asylum. Again, I'm Brian Manning, and it's an honor to serve you in your asylum journey.